Greetings. Hello. Hope everybody's well. Not legal advice. Please like, subscribe, share, comment. Greetings to everybody who is here. StreamYard, Born Free Films, Zach, Renee, Donna, Scott, and then Renee again. Those are two Renees are here. What a coincidence. What do you think the odds of that are? But, the world is an amazing place, so such is the world. I was going to talk to you today not about GTII, KNOTT. I think the name of this stream is not a GTII update, or is it better to give than receiver, if you get it. So I'm going to update you, and then I'm going to talk about the audit. I'm going to bring that up again, and then I'm going to talk about emotion, not emotion, but I'll talk about emotion also if you like. If anybody wants me to talk about emotion, I'm happy to do that before I start talking about all these crazy topics. Crazy. My roofer, I'm putting on a new roof on my house. By the way, today I'm in Southern California. Today, at least where I am, it will be, I think, 81 degrees, which might be slightly warmer than some of you in other parts of the world. If I could spread some warmth, I will. Obviously, if you followed the news, you would think that LA and its surrounding areas were like Beirut. May not quite be that way. And what LA really, or the surroundings, I don't live in LA, I live near LA. But the weather, obviously, in Southern California is pretty amazing. And the geography, the mountains, the deserts, the sea, all that stuff, geography is amazing. I think those are the two biggest pluses. So props to SoCal, because you don't get enough props. And I'll leave it at that. Anyway, getting back to my roofer. I'm getting my roof done, and my roofer told me that the most common diseases that roofers get is shingles. The same guy, my same roofer, who was at my house, who's trying to avoid shingles, told me also that AI's favorite style of music is algorithms. And at the same time, he told me this joke that I didn't think was very funny, but he told it to me, and I'm going to tell you anyway. The roofer, who again is trying to avoid shingles, he told me that a machine learning algorithm walks into a bar. The bartender says, "What do you have?" And the machine learning algorithm says, "What everyone else is having." And last but not least, that was a very deep joke, by the way. And last but not least, what do you call a blonde android who dyes her hair, or its hair, brown? You call it artificial intelligence. All right. So two things I'm going to talk about. Since we haven't spoken. Now, you can't speak to me, so I don't know how you're going to speak to me, but we haven't spoken in a while. Anyway, but I want to talk first about the audit. I wasn't going to talk about it, but I was going to talk about it. So here's my thought on the audit. So I have not seen the final audit. Obviously, the reports are it's imminent, it's soon, or whatever. And I was thinking about the sequence of events, and just keep this in mind because it may come up again. I understand that people that may be that will oppose whatever I say may be watching this at some point in time. If you are, or if you're watching in the future, greetings, and please like and subscribe. Nothing is going to be secret, so to the extent I file something in court, they're going to get it, and they're going to have an opportunity to oppose, respond more so, as they've done before. And they will or will not. But so I'm not being secretive. So that's why I'm disclosing this stuff to you today, all this exciting stuff. So first, let's talk about the audit. So I was thinking about the audit. So if you recall, maybe you don't recall, but the original auditor got shit canned by the SEC. The old management brought in Fortune to do the required audits. Fortunes were brought in by the old management. When the receiver was appointed, he kept Fortune on, and I think that was from like September of 2024 through something like January of 2024. Now, I even mentioned at the time, I think I mentioned at the time, I certainly thought at the time that was a bad idea. Why would you keep on anybody who was affiliated with prior management? But perhaps they thought that Fortune was going to complete it quickly, that they were competent and ethical, and the fact that they were working for prior management should just be ignored. But whatever the basis, they stayed on, but they had to get rid of them because it didn't work out. Didn't sound like Fortune was helping them. At least that's the message that's portrayed. So then they hired their own. And I don't know the sequence of events, but their own, the person who was running it, because they put this in one of their reports, went out on maternity leave. So didn't they know that when they hired her? And if they knew it, why would they hire somebody who couldn't complete the audit? Or did they just make an error? Or did she not tell them? Because if you recall, during the last hearing, the Receiver's Counsel indicated that once the person who went out on maternity leave, and that's fine, babies are good, but the person who went on maternity leave, when she was replaced, those people had to redo all her work, which further delayed things. So that didn't make sense to me. Did somebody goof by not following up properly? Was some information not disclosed? Because if somebody was pregnant, then perhaps that should have been known, one way or the other. So I would like an explanation about that, and that was one of the reasons I was asking for a representative of the auditor to be at one of these hearings so we could hear the explanation for why it's taking this amount of time. Now, perhaps that will be done quickly, but I don't know. But, if there was not enough diligence done, then that would have been the responsibility of the receiver. And perhaps this is one issue where he should have done a better job. Now, again, I have no qualms. No, I have some qualms. But receiver's doing his job. It's a tough job. I don't know what exactly he's doing, but he's doing a job, and that'll get into part two. But he's acting as a receiver. That's probably meeting people and calling and reviewing documents, I guess, because he also has a CP, I guess, a forensic accountant. He has an auditing firm. He has the lawyers that represent him that do the litigation here. He has some corporate lawyers, I think, in Texas. He also, I think Dylan Siciliano indicated at the last hearing that they had hired another counsel to review the terms of the open deal with AIversity. So that's a lot of people doing a lot of tasks. So I really don't know what specifically the receiver is doing, honestly. Is he doing accounting work? If he has all these accounting people, he's not an attorney. So I don't know what he's doing, honestly. But he's responsible theoretically, and perhaps if there's a bunch of, I've raised a few issues with regard to the audit, right? So who's responsible for that? The person who chose all those people ultimately. So I would like an explanation. I still don't feel like I've gotten an explanation for those choices and the delays, and certainly not why the work had to be redone, even at the auditor that they chose. That didn't make much sense. But that's currently not before the court, although on the 19th, I think on the 19th, there is a status hearing, and I might file another, I haven't decided, but I might file another declaration about the audit, and I'll address the issues that I just brought up in that. I hadn't thought about this. So there's a status conference on February 19th, along with some other hearing. That's open to everybody. I think the new counsel for some of the shareholders um, referenced that it would include a status conference as to the audit, et cetera. So we will see, and I will certainly file something beforehand again if need be. So that's the audit part. I really wasn't expecting to talk about that, so I just kind of blabbed on. The next part was on January 23rd, so that's a week ago, and you have 14 days, according to my review of the Nevada rules, 14 days to file an opposition. So the document was served on the 23rd, so opposition has to be filed a week from today. I will be filing something before that. And the document itself is called the receiver's third motion for interim order and allowance of and payment of receiver's fees. And in it, he describes what he's seeking and what he's done. And he basically says that as of now, and I'm going to follow this through so we can kind of think about it a little bit collectively. So I guess he's recovered about another 80 grand since the last time. He's entitled to 86,400, I guess is what it says. And that's that's been over quite a period of time since the last application. And on top of that, he's gotten back 5 million shares. Excuse me, he's gotten back, and that's including those uncontested shares, like 40 million. Oh, it's here. 40 million and change from the freeze order, where there was a bunch of disputed shares. There was an order they were allowed to oppose. Some didn't oppose. That amounted to about 40 million shares. 11 million shares from Kathy Griffin. She kept a couple million shares. I think her daughters kept some, I think. The receiver's counsel says that she's been very cooperative and helpful. That's why they let her. And sometimes there's reasons to do this kind of deal. So I'm not gonna argue about that. 137,000 from Scott Oliphant. That was one of the attorneys who was deposed. 110,000 shares from Rachel Rothenberg. And then that adds up to 51,436,948 shares. So he wants 10% of that, 5 million shares, which he valued at, which I find interesting. He valued that at its current value. Well, yeah, I valued it at a penny, but I think it's at 2 cents today. But that's how he valued it. So he showed that what he received was only 60 grand, or what he's asking for is 60 grand, 76.95. I think that if that's true, then he maybe should accept payment in that amount. That's what he thought he was interested in. But anyway, in it also, and they try to justify what's going on, certain recoveries, which I can't argue. The sale of the Range Rover, getting back some cash, although that has obviously stopped. That it was really hard. That they're close to getting the audit done because the GTI gold transaction is the last hurdle, although I'm not really believing in that. And that's basically summarizing whatever. So I was thinking about that. So one of my problems is I think, and again, I'm not a Nevada lawyer, so this is just my impression, but I believe that the compensation of the receiver, notwithstanding whatever the agreement is or whatever the order is, it's got to be reasonable. And if, as the Receiver's Counsel indicates, it's likely they will get back 150 million of the 300 million shares, which would make the outstanding amount 150 million, if that is correct. Per what the Receiver's Counsel indicates, the receiver might get 15 million shares. So he would have a 10% ownership interest in all the stock of GTII. Now that I don't think anyone could claim would be reasonable. And that would be if the receiver was performing all the work and all the tasks. And then I'm going to explain why that's important. So let's say there was no counsel, no accounting, no forensic accounting, no second forensic accounting, and the receiver was an accountant, and he was doing all the work, the financial work, and he was strategizing and leading the legal work. Perhaps there can be some argument about the value of services, but in this case, I don't know what that value is. I'm sure there is value, but I just don't know to this point in time. So first of all, a 10% ownership is not reasonable. But on top of that, the legal fees just to the firm that's representing, the Dillon's firm, that firm, which I think has done an excellent job, by the way. So I have props for these guys. I have no objection to them getting paid. I think they've done a fine job. I know that Dillon and I have butted heads at times, but we're fine. And I have no qualms. I think they're doing a job. But I think, because I got this information directly, I think through either the end of October or beginning of November, that law firm has received payments of approximately $500,000 on this case. Now, and again, I can vouch for it. So they've done a lot of work. I think they've led the charge. I think all the recovery, almost all the shares that were recovered, almost all the money that was recovered is in large part through their efforts. So I don't have a problem. And it's not money directly, it's indirectly out of my pocket, but not directly out of my pocket. But even if it's a large amount, they are actually doing things, and because of their actions, things have moved on. On top of that, there was another law firm in Texas. I don't know how much they were paid. There's that law firm they mentioned that's reviewing the AI-versity deal. I don't know how much they've been paid. There was the forensic accountant that the receiver had hired. I don't know how much he gets paid. And then there's the auditing firm that's doing the audit. I don't know how much they're getting paid. But if you put that all together, honestly, we're probably approaching $1 million in fees and costs. Now, those may be all justified, all due, all appropriate, but they're dealing with essential tasks of the receivership. And, usually in a receivership, the receiver would be compensated based upon his time spent. And in this particular matter, he chose a different route. And my concern is ultimately, again, one is reasonableness, but are we, and I don't mean this that it's done in a malicious or underhanded way, but it seems as if we may be getting double charged for tasks because we don't see what the receiver is getting paid for his time. We don't know what value he's been provided. As an organizer and picking the law firm and picking the forensic accountant, and I would, I have my druthers, I would argue about how the choices of accounting and auditors has been done. But if it's just being a manager, then does a manager deserve to get 10% ownership in the company? Of course not. Doesn't make any sense. So besides the fact that if they are correct, he will have 15 million shares. I don't know what value he's provided. I'm sure he has, but I just don't know what it is because of all the other fees and experts that he's had, which is a good idea, but you don't get compensated. You shouldn't get compensated twice for the work performed by the people that we are paying. So this doesn't really make a lot of sense about it to me. So So we have the issue of the reasonableness of the fees, that he could have 15 million shares and own 10% of the company. The second part is, again, what are those shares worth, and why should he be able to sell those shares before others can? Because as of now, there's no restriction on him selling the shares. There may be legal restrictions, but that may be subject to interpretation. I don't know if he's an insider. I don't know what the restrictions would be. But as of now, there's no restrictions on him getting rid of shares. So what happens if he gets his 15 million shares and all of a sudden he dumps them? How do you think that's going to be on the value of the stock? And perhaps, whereas most of us cannot trade the stock, perhaps because of his large number of shares, perhaps he will find an outlet to trade his stock. And even though he valued the amount here at 1 cent, is he limiting his return to 1 cent a share? Because if that was the case, if it's 15 million shares times 1 cent, I think it's 150 grand. I'm sure that we would enter in that deal. You bring in the 15 million, 150 million shares back, and we'll give you 150 grand. I'll enter in that deal tomorrow if that's what he thinks. But otherwise, without a restriction, he could dump his shares, and the impact on the rest of the shareholders, even if they were able to trade, would be monumental. The downward price pressure would be ridiculous. So, in addition to the unreasonableness of him being the owner, of the uncertainty of what value he brought, I think this added factor is another something else that needs to be considered by the court. And so I will be filing a brief before 1 week from today, and I'll let you know when it's filed, and I'll be raising some of these issues. And I will also, for the hearing on the 19th, I'll wait closer in time, because maybe the audit will be done. Wouldn't that be a miraculous thing? But perhaps the audit will be done prior to February 19th. I don't really believe that statement, by the way, but wouldn't that be a great surprise if that was the case? So just to reiterate, on 2/19, there's a status conference, and the audit will be discussed. On 3/18, that's the date of the hearing on the receiver's third motion for interim order, there will be a hearing on his request to get paid $8,600, which I'm not going to oppose that, because that's fine, whatever that is, and an additional like 5 million plus shares for bringing in 51 million shares. And in the documentation, I think it was in the 6th interim report, might be in this motion also, the Receivers Council intimated that they may bring back half the shares, which would be 150 million shares, which would mean that the receiver, according to the current stuff, would get 15 million out of 150 million existing shares, which would mean he'd have a 10% ownership. And how could that be possible? And then I sprouted along. I said, there's a bunch of experts, and I gave credit to the great legal team that's doing the litigation, but who's been paid. This is just through the beginning of November, about $500,000. So I don't know how much more, but there's a bunch of other lawyers, a bunch of other CPAs. So what else is the receiver doing? And in effect, are we getting charged twice, but only getting one service? That's the question. And is that fair? And it's more because I just don't know specifically what the receiver is doing independent of the professionals he's hired. And if he was being paid by the hourly, we would know that, but we really don't, because he doesn't have to present that kind of background, but perhaps he should. Perhaps if we saw some kind of, I guess that would be a way, like lawyers have to do timesheets, so they do entries, and you could read generally what they spending their time and money on. It would be interesting to see the timesheet for the receiver to understand how much time he's placed, and to judge the compensation based on that. But based upon the amount of money spent on other professionals, it seems I question that. I question it. I'm not certain of anything, but I question that. Anyway, that'll be hearing on March 18th. I know that they're trying to set up and they're setting up another deposition of the attorney. So I'll do that. And last but not least, and this is not with any certainty, but my strong impression is that AIversity is waiting for the people at Gtii to contact them, and unless there's a contact, there won't be any. I don't think this deal's going on. It's my impression. Now, may Gtii contact AIversity or counsel? That I don't know, but I think my recent impression is that there hasn't been contact in a long time, that AIversity is still waiting. I don't know what GTII's position is on that, but it doesn't seem like they're in discussions. Now, does that mean that no deal will be made? Possibly. Does that mean that a deal could be made with some other entity? That's possible. I wouldn't be surprised if the receiver has some associates that they might do a deal with, but then my concern would be what's the real effect on the stock, and can retail get out? But it would seem like if the stock can't trade and if the receiver is unable to trade his stock, that he would need some kind of event to let him trade. But I don't know if that would be in the best interest of other shareholders, depending upon when other shareholders could exit. Because again, if a deal, let's assume that, no, I'm just pure speculation here. Let's assume that audit's done, some AIversity deal is not done. A receiver puts together another deal with some flunky because of that, and it's able to be traded. So because of that, the stock price goes up. Sounds like the history of the stock, by the way. But the stock price goes up and the receiver is able to liquidate his shares before other shareholders. What? I mean, does that sound like a good outcome? It does not to me. So I hope that the judge will see that and place some restrictions, even if it's on the on when the receiver can get rid of his stock. But I think it really makes sense if the compensation is more plainly spelled out, so we all know what's going on here, really. And again, I really would like to know what specifically the receiver is doing, because I know a lot of the experts, the counsel, again, litigation counsel, I think is doing a fine job. That's Dylan. The rest of the people I don't know about. I have questions about his the auditing firm, because they're just an odd state of events, that we have a maternity leave, then we have to have a review of everything's done, etc. Maybe again perfectly legitimate, but in light of the prior auditing history where the SEC shut down the first auditor, where the second auditor chosen by management basically blew off the receiver, and the receiver's choice of auditor then went on maternity leave and had had to have everything reviewed. I mean, I think that's what the receiver is supposed to be watching out for. But anyway, what do I know? I'll let you know when the next pleading is filed. I'll let you know when the next depositions, etc., happen. If you have interest in AIversity, feel free to reach out to them. If you want more clarity on what's going on in terms of deal making, certainly you can indicate your preferences to the receiver, but do it in a gentlemanly way. Because if you don't, when we go to court, because it happened the last time, when we go to court, the receiver's counsel is going to use that to negate the validity of whatever our claim is. So whatever contact you have with any of the professionals or the receiver, do it in a cordial fashion, even if you're pissed, because I know we're all pissed. But do it in a cordial fashion so it won't come back and bite us in the butt. That's my recommendation. So anyway, next hearing is on the 19th of February, which is 3 weeks approximately. And then March 18th, I'll keep you apprised. And again, about deal making. If you have deals, contact the people, express your views, and go from there. Again, I don't think the receiver can get out unless he could trade the stock. So it seems like he has an interest in getting a tradable. It's when we can get out relative to the receiver that I think is the issue. And I think we should all be clamoring about it, honestly. Or that's my opinion. Just my own opinion. We all should be clamoring about it. Anyway, to everybody out there, be well. To the people out who are going to have a cold weekend or snow, be well and be safe. Take care, and I'll talk to you soon. That's all for